Welcome, everybody. Let's go ahead and get started. Thank you all for attending this roundtable discussion on Fisher versus the University of Texas. It's an incredibly important case for those of us who study the Supreme Court, constitutional law, and affirmative action more generally. I'd like to first, though, introduce Provost Lerman, who will provide some welcoming remarks, and then I will turn and introduce the panel to you all, and then we can get started, okay? But first, Provost Lerman.
Well, first of all, thank you all for coming here. On behalf of President Knapp, who sends his regards, he is at the Clinton Global Initiative in New York, so he would otherwise be here, of course. And he asked me to send his greetings and welcome, and of course his thanks to the panelists. I'd also like to thank the organizers, Professor Alan Morrison and Chris Bracey in particular, as well as Dean Paul Berman. And of course, a welcome and a thank you to our special panelists who have come here and taken up their time to help educate us about this very important case. This is an important debate, and it goes beyond, of course, universities. It's like many important Supreme Court decisions will affect us in many different ways. As a university, we, of course, have a vested interest in creating and attracting a diverse student body, a diverse faculty and staff, and creating an environment in which we learn from each other to the maximum extent possible. Of course, this case will help define the legal boundaries in which those clear objectives can be met. It may affect public schools, it may universities only, it may end up affecting us as well. How that all turns out, of course, we have a vested stake in, and it is by no means a secret that we, as a university, filed as part of one of the amicus briefs. We were joined by 9 other schools in doing so in support of the state of Texas in this case. As an engineer, and for those of you who don't know me, my background is as an engineering faculty member in civil and environmental engineering. The issues of diversity, of course, become even more acute when one looks at the distribution of underrepresented minorities in those fields. And many universities, including our own, continue to go to great lengths to attract young people of color and women into science, technology, engineering, and mathematical disciplines. And so again, how we can achieve those objectives and the ground rules for doing so will be in no small measure be set by this case and other cases. We continue to believe here that it is important to find the ways to attract a diverse body of students here. We thrive from that diversity. We learn from each other. We gain different perspectives. There's also a body of evidence in engineering, in particular where I'm familiar, that when confronted with engineering problems, diverse groups, and diverse measured in many different ways, and certainly not exclusively with respect to race, diverse groups of engineers tend to produce more innovative solutions. That is to say that they produce solutions that many of us would think of as out of the box. And part of that, it is believed, although of course the evidence here is very hard to substantiate, that diversity itself fosters a wider range of thinking by bringing together teams. And again, in engineering, particularly the discipline I come from, many things are done in teams. And the more diverse the team, often the more diverse the space of solutions that people begin to explore. So with that said, this panel is an important example of the type of dialogue that should happen at a university. This is a place for critical inquiry, for exploring divergent views, for understanding what the law has to say to us. I made it clear, I think very early in my introduction, I am not a lawyer, and nor do I purport to understand all the legal aspects of this case. And part of the value of panels like this is to educate us. But as an individual, I treasure the creative and thoughtful dialogue that panels like this create. We are always better served by listening to divergent views, making our own decisions, hearing what people have to say in a thoughtful way that allows us to understand the issues. With that said, I couldn't help but editorialize that sort of debate, which is what a university community can and should be about, is now become all too rare in our society. You don't have to watch every commercial on television in the current campaign to get a sense that thoughtful, deep, insightful, critical debate informed by facts and reasoned thinking is a rare commodity in many circles. But in this case, that's what we're here to do. We're here to listen, we're here to learn, we're here to ask questions, we're here to understand the legal, ethical, and social issues of an important case. And in doing so, I think we foster the precise environment that we as a university want to. So with that, welcome to the panel. I'll turn it over to Chris, and I hope this will be as fascinating as I fully expect it to be.
Thank you, Provost Lerman. I think your comments are exactly right, because affirmative action really has been a defining issue, at least, for the last 40 or 50 years. It's the defining issue of the post-civil rights era. And at bottom, it's a question of disparity and underrepresentation. Historically, the question was focused on employment, then moved into education. The early justification for affirmative action was largely remedial, making up for lost ground and lost time. Today, the operative justification is diversity, but each generation has had an opportunity to examine the affirmative action question and debate it. Every presidential administration has dealt with this question, and each Supreme Court corresponding to those presidential administrations has debated this question. And so it's high time for our generation to have a conversation about it as well. What I want to do now is introduce you to your panelists here. To my immediate left is Erik Jaffe. Erik is an appellate litigator with practice covering a wide variety of legal issues in both state and federal courts of appeals. His practice focuses primarily on constitutional issues and litigation in the United States Supreme Court. He has filed a brief on behalf of the Asian American Legal Foundation in Fisher. To his left is Andrew Grossman. And Andrew Grossman practices appellate litigation with a focus on constitutional law and administrative law at Baker Hostetler, and he's a legal fellow at the Heritage Foundation. Mr. Grossman has filed a brief on behalf of the Cato Institute. To my immediate right is Josh Civin, counsel to the Director of Litigation at the NAACP Legal Defense and Educational Fund. Civin is representing the First Ward on New Haven's Council Board of Aldermen, and he is also actively pursuing and participating in this case. And then last but not least is Deborah Archer here. Deborah Archer is the Associate Dean of Academic Affairs at New York Law School. She's also the director of the school's Racial Justice Project, aimed at protecting the constitutional and civil rights of people of color. She's filed a brief on behalf of the National Black Law Students Association. And I am Christopher Bracey. I'm a law professor and the academic dean here at GW at the law school. What I want to do is begin this conversation with a discussion of what the current admissions process is like at the University of Texas, because ultimately this case is going to turn on that narrow set of facts. And although many of us have been engaged in policy discussions from time to time about affirmative action, it's important to understand exactly what the court is being asked to consider here. So let me start with Erik. Erik, why don't you tell me a little bit about the current holistic system that is employed by the University of Texas and how it works? What's the issue?
Sure. Okay, so Texas lets in the bulk, University of Texas at Austin, the flagship school in the University of Texas system, lets in the bulk of its students under something called the top 10% program. So if you're in the top 10% of, I believe it's any Texas high school, you're in. You get into the school. That, I think the latest numbers I saw were that it's between 75 and 80% of the student body gets in under that program. For 25, maybe even 30% sometimes, they then get in under sort of the more traditional approach to admissions. You apply, they look at your numbers, they look at your essays, they look at a bunch of factors about you and let you in. This case matters more for those students, though a little bit for the top 10% folks too, which I'll get back to. But for the students not in the top 10%, they get a blended score. Part of their score is academics, class rank, SATs, grade point average, and that's called the academic index, I think they refer to it as. Mm-hmm. The other half is called a personal achievement index, and that takes into account lots of things. It takes into account your essay about, your life and your experiences. It takes into account extracurriculars, any special circumstances. Did you come from a poor background, a rich background? Did you travel a lot? All the things that, sort of the squishy things that go into admissions processes. And, under the current program, race. So race is part of your personal achievement index. So in case any of you are wondering, your race is an achievement. You have achieved something by being whatever race you happen to be. At Texas, however, you only really achieve something if you're one of two underrepresented minorities, either African American or, well, I guess it's not just African American. It may just be of African descent, whether or not you are necessarily American as long as you're in school here. But be that as it may, African American and Hispanic. And for those two, what Texas defines as underrepresented minorities, they get some, though, as an undefined plus, sometimes, maybe, if Texas feels like it, when they're talking about it. It's really not clear. Even having reviewed their brief today, they go back and forth on whether or not it matters. So maybe you get a plus, maybe you don't. Maybe they think about giving you a plus, but if you don't have other qualities that make them want to give you the plus, they don't. But at the end of the day, I think it's safe to say that the only way this case matters is if some people get a plus and get in who otherwise would not. And that is a function of the personal achievement index. So then they take one axis of a chart is personal achievement, the other axis is academic achievement. They run a line down, they group everybody by combined scores in a bunch of different boxes, and then they run a line through the middle to get the right numbers. And wherever you are on that chart, you're either in or you're out, is roughly the way it works. And once again, the only way this matters is that if the racial component of the personal achievement index takes some people and moves them into a box that is in when they otherwise would have been in a box that's out. If it doesn't do that, this whole case is pointless, and I don't know why we're talking about it.
Okay, well, Josh, do you have something to add on that? Because,
Yeah, I mean, I think that is, in some significant ways, a flawed representation about how the admission system at UT works.
Sarcastic, I'm not sure if it's flawed.
Well, I mean, I think that the important point is that so the majority of, I agree, the majority of students get in through the top 10% plan. That plan is created by the legislature, and the legislature passed a law, and the history is important here. The legislature passed a law as one of a variety of race-neutral steps that Texas took after a case called Hopwood. The history is important here. Hopwood was a case back in 1996 where the Court of Appeals for the Fifth Circuit, which is the region in which Texas lies, said that diversity wasn't a compelling interest, and therefore you couldn't do a plan that took into consideration race. The Supreme Court subsequently overruled that decision effectively in a case called Grutter in 2003, which upheld the University of Michigan Law School's plan. It was actually a case along with another case called Gratz, which struck down the University of Michigan's undergraduate plan. So it was a split decision, but it provided a lot of guidance for universities out there about what you could do and what you couldn't. And the essence of Grutter was individualized holistic review with race as one factor among many. So back to Texas. So Texas was faced with this situation in 1996 of they're not allowed to use race as they previously did. They tried all sorts of race-neutral efforts, including expanding scholarships, outreach, and the legislature, sort of working in a creative collaboration with the university, which doesn't always happen, but sometimes it's good when it does. The legislature said that if you were in the top 10% of your class at a Texas high school, you'd get into the school, although not necessarily into the major. And that's important because you're admitted to UT based on your major or your school. And the admissions works school by school and major by major. So those matrices that Erik was talking about are school specific.
So how does the 10% plan, though, actually achieve some diverse outcome?
So the top 10% plan, so Texas is a, unfortunately, despite a lot of efforts by courts to integrate K through 12, in part due to neighborhood segregation that persists in our nation, Texas remains a significantly segregated state, so that there are a lot of high schools that are predominantly of one race or another. And so there is some measure of diversity achieved through the top 10% plan by virtue of the fact that schools are overwhelmingly of a predominantly black, predominantly Latino, predominantly white. And so that brings in a measure of diversity. But during UT's experiences between Hopwood and between Grutter, so 1996 to 2004, UT really struggled with and tried to use all these race-neutral options, but found that African-American students never comprised more than 4.5% of the class, that Latino students never comprised more than, believe it's 17% of the class. And so they wanted to ensure, there were actually a variety of other measures they took into place. It wasn't just those aggregate numbers, but I put those aggregate numbers out there just for purposes of situating this case. And the system that they put in place is not a system where only, and this is where I disagree, only people of one particular race can benefit from their race being considered as part of the process. What UT did was it took careful review after Grutter to decide whether to consider race and determined that for a variety of reasons they weren't fully realizing the benefits of diversity, that African Americans and Latinos were underrepresented. But having made that determination, they then didn't say only African Americans and Latinos can receive a benefit. Rather, they said, we want to include race as one factor among many for all students to be considered as race as part of their unique background. Now, it also is undisputed in this case that race actually is meaningful, and as a result of this individualized review, African Americans and Latinos, there's been a meaningful contribution to their representation on campus, but not just on numbers. Also, and this is important, diversity within diversity.
So we get some more rich kids, doctors and lawyers kids who are of color, is the diversity within diversity, at least as the university describes it, right? So that's the diversity we're talking about.
No,
just so we can be clear.
I don't think
they
that's
want to make
fair
sure
at
it's
all.
not all poor kids.
But what do you think, Andrew?
That's what they said.
What do you think, Andrew? I mean, is the diversity that Texas is trying to achieve by adding this holistic approach on top of the 10% plan designed to produce that particular kind of diversity within diversity, which is just elite kids now joining the less elite kids as part of the diverse cohort, or is there something else going on?
Well, rather than try and characterize myself what it is that Texas is up to, I think the university actually speaks to this directly in its brief before the court. The example they give is the African-American child of an orthodontist in Dallas. Their rationale is that many of these types of children, many of these types of students would be in schools that are more integrated and would face a more difficult challenge in getting into the University of Texas, Austin through the top 10% program. So that's specifically what it is they seem to have in mind by this sort of intra-race diversity idea.
I just want to follow up on your point that you said that it's not all poor kids, and I'm not sure why that's a bad thing to want to make sure that if you have racial diversity, that not all of that racial diversity comes from folks who are poor and lower socioeconomic classes. It's a benefit to show that there are minority students who are not poor. It helps enrich the learning environment and the sense of diversity, and get what Josh said, diversity within diversity. So I'm not sure why it's a bad thing, even if the University of Texas wanted to make sure that not all Black and Latino students that were students there were poor.
I actually fully agree. The problem is not that middle class and upper class kids of color can't get into the University of Texas. They actually could if we just got rid of the top 10% program. They'd get in on their grades because they go to good schools, they do well, they have good educational backgrounds, their parents have good educational backgrounds. These are exactly the kids who get in all by themselves. The reason they're not getting in is they're getting bumped out because of the top 10% problem, and maybe they're in the 11th percentile in a very good school, which would still get them in on their grades and on their numbers, but closes them off when they then have to compete in this sort of skewed, mostly top 10%, everyone else gets lumped into a pile, and of all the kids who are not in the top 10%, then the average grade points of those kids are actually shockingly high, even if they're not in the top 10% of their schools. And so they end up competing in an artificial environment, which is why you need race to get them back in the first place. They would have gotten in all by themselves. It would have been fine.
So I don't think the facts actually bear that out. If you look at studies across the country, and also, for instance, at University of California's experience when the state, through referendum, banned race-conscious admissions, it turns out that so if this were a system that had fully individualized review, universities across the country have looked at this and seriously considered, and the studies bear this out, that race as a factor there is necessary to ensure a critical mass of. That's what Bruder was about.
Well,
that
but
was
doesn't
with the
contradict
University
what
of
I
Michigan.
said, right?
Well,
I didn't say there'd be as many black students. I just said the better off ones would get in.
Oh, I see. So effectively,
Well, the poor kids would get in.
well, so.
Well, what do you think,
I
Jim?
mean, so UT's experience, which we're talking about here, is that socioeconomic status is considered as part of its holistic review. With socioeconomic status considered, it turned out that there was not, in UT's view, after significant consideration, diversity within the non-top 10% pool. And let's be clear, the non-top 10%, the university was giving the example of an integrated school as a student from an integrated school as one of the benefits, but I think we have to remember what individualized review is important for, and a lot of schools prioritize grades, and they prioritize SAT scores. But we all know that those aren't always the whole story, and in fact, in many situations, if you look solely at top 10%, you're not going to get a student who takes a risk and takes calculus in their junior year. And turns out that that student struggled the first semester of calculus and then got into the swing of things and was just fine. That's a student who took a risk by taking calculus, that we probably want risk takers. We want to encourage entrepreneurial people. But if you're focused solely on, are you in the top 10% or not, you might miss that student. And if those students are important for a variety of reasons, it's important that those students are diverse as well.
So I want to transition the conversation a little bit here and talk about the role of race, because Erik said, the only reason why this case matters is because presumably race is of decisive importance on some level at some point in the decision-making process. So there are going to be people who are getting in because of their race where they otherwise would not get it. But I want to drill down a little bit on this because I want to know what sort of assumptions underlie the use of race. Now, Deborah, you had mentioned earlier that what's wrong with diversity that is sort of class stratified within a particular racial group. But are there any assumptions that are working beneath the concept of race that help explain why we think a racially diverse class is significant or meaningful?
So I know you want to jump ahead, but I just want to jump back for 1 second.
Okay.
Because I don't want to leave out there the idea that this is a point system. You said that race may get you 1 point, it may not get you 1 point. In fact, in the UT system, race doesn't get you any points. And that's part of the benefit. It's a holistic look at the student, at the applicant. And so race may be a factor, but it's not that race is assigned 1 point or 2 points. And it's not that only African American or Latino students can get consideration of race. If there's a white student who attended a predominantly Latino school and ended up being class president, their race is a factor, and their race is relevant to the achievement that they've accomplished. And it should be something that is considered.
If I may.
Please.
I think part of Texas, the University of Texas's innovation here was not to use points. In point of fact, the system that they use, what they call the holistic system, isn't exactly the type of holistic system that might be applied at the Ivy League universities and at much smaller liberal arts schools. The University of Texas is a very large school with tens of thousands of students, and as the administration of that school has explained, it's very difficult for them to give a truly holistic review to every application that passes their desks. And that's even true for students who are considered under the PAI-AI standard. What they actually do is they've constructed a grid, and I think Erik explained that relatively well, but the idea is that the way that race is considered is that when race is a factor, that student jumps up to the next box in this matrix grid. Sometimes they call it a matrix, sometimes a grid, and that affects where they fall when they ultimately draw the line for admissions across that grid. This is interesting to me because the system that was struck down in Gratz was one where the University of Michigan actually gave point scores based on racial identity. In this instance, the University of Texas has avoided doing that by simply transforming the cold calculus of numbers to some sort of graphical, graph-based system. In reality, there actually is some amount of symmetry between the two ways of doing things. University of Michigan could have used a grid. University of Texas could use numbers. And algorithmically, they actually could arrive at the same results. But in this instance, the University of Texas was very, very careful not to do that because they know, given the way that the Supreme Court has framed these issues, that numbers are completely taboo. They're something that can't be a part of any one of these systems. However, I don't think, in the way that they structured their program, they thoroughly internalized the rulings of Grutter and Gratz and really tried to give the type of holistic consideration that the court talks about in those cases, for the reason that would be very difficult for them to do. The district court opinion in particular in this case delves into that in great detail, I think actually in somewhat more detail than the Fifth Circuit or the briefing before the Supreme Court.
Well, Andrew, let me follow up, because you did mention that there were some numbers and there were points, and you suggested that the use of race would actually jump a candidate up from one cell to another cell on this grid. My understanding, though, is that the Personal Achievement Index, which is that holistic review, takes into account a number of factors. Race is just one of them, and that based upon the holistic review of those factors, there is a number that's attached. That number may be higher or may not be higher because race is taken into account. It's hard to know, right? In other words, but what that means, though, is that you're not going to necessarily jump from one cell to another, right?
Well, actually, that's I think that's not actually the case. The way the school at least describes it, and maybe they've changed their practices, but the way the school describes it, they actually don't use numbers at that stage of the evaluation. Race, when it's applied as a plus factor, actually does jump a particular candidate into the next matrix box, which then might make it more likely that they'll wind up on the right side of the line for admission.
Okay.
Let me just say, no, it's unquestionably that way. So you get a 1 through 6. You get a 1 through 6 on your point score.
Yeah, you do.
And if race as a factor doesn't change you from a 4 to a 5 or a 5 to a 6, it has no impact on admissions. So to the extent that race has any impact on admissions, the only way it does that is by giving you 1 more point or 2 more points or however many more points than you would have had but for race. Because if it doesn't move you up a number, it doesn't change your box and it doesn't let you in. So either it has an impact, and then let's just talk about whether it should, or it doesn't have an impact and this is a complete waste of time. Josh?
So I think what I at least am taking issue with is not that race is significant for some students in terms of their admissions. It's the automatically jumps you up.
I didn't say automatically. When it has an impact, the way it does so is by giving you a point.
But it may be that race in conjunction with what Chris was talking about, the other special circumstances, and then factored in with the essays, because it's only 1 score for personal achievement. And that 1 score includes your essays, it includes leadership, it includes extracurriculars, it includes all of these factors. So it's viewed in conjunction, and that in conjunction is the whole total of that.
That's misleading, because either race matters or it doesn't. So viewing all those things in conjunction without race gets you a 5. Adding in race gets you a 6. What's the difference? Race. So you could say it's mixed in with 50 other things. It doesn't matter. If it has a marginal difference, then it has a difference in admissions.
It's not as if all students of one race get a point and then that moves them up. That's not the way this program works.
One problem I think that we all face in discussing Texas's system in particular is that we're operating with a paucity of facts. The university has been very unforthcoming about how exactly it applies race in review, the number of students who are affected, who gets the plus, who doesn't, precisely what criteria they use to determine that. In fact, in this case, there's been a question of would the petitioner actually have been admitted to the school, had this system not been in effect, had the consideration of race not been in effect.
Do we have any information on that?
The university's response was we would have to rerun the entire admissions process for that year to actually determine that. And with respect to the number of students who are admitted based on racial factors, the university actually refuses to put a precise number on that. At some points in their briefing, they claim that it's all of the students, all of the minority students, who are admitted through the AI-PAI system. In other instances, they're a little bit clearer and say, well, we really can't tell you because we don't know. And that's something I think that in discussing these issues and trying to work through the numbers, it makes it very difficult.
I think that's right. Yeah.
There's been a remarkable lack of transparency, and unfortunately, I think that's not unusual for these types of systems.
And so I take it it's also equally difficult to tell if the petitioner was even close to being admitted, right?
The evidence that there was she would have been a competitive candidate, they actually bifurcated the case in the district court so that that's something that potentially would be addressed on remand if the petitioner were to win.
Okay.
Well, I think that sort of speaks to the fact that this is not a science, that it's not an equation and here's the result and so you're in or you're out. I think what we want with the holistic review is for there not to be an equation that this is worth 2 points, this is worth 3 points, and therefore I can tell you definitively whether someone is in or out. The fact that this is more of an art and a review of a variety of factors that come to play in a different way depending on the different student is a good thing and not a bad thing, not something a university should be faulted for because they can't give you the exact equation they're using as they look at and evaluate each student.
Well, that brings us back to the question I wanted to ask you
Yes.
earlier, right? Which is what sort of assumptions underlie the consideration of race in and of itself? You know, for instance, is a person's racial background ever verified when they apply?
Well, I don't know that you would want to because for me, someone who appears to be white but identifies as black for various reasons from the neighborhood they grew up in, the people who they were surrounded by, the aspects of culture they embrace, to me it makes an interesting person as well and maybe someone you want in your class. But what troubles me about what the petitioner is asking is that it's not that they're saying let's get rid of a holistic evaluation, it's that let's have a holistic evaluation where every aspect of a person can be relevant except the fact of their race. And despite all of the successes we've had recently with Barack Obama's election, we would be naive to say that race is not relevant. Race is incredibly important to who I am. It's incredibly important to who a lot of people are. It's not something you can remove like a coat or a jacket and say, well, now this is who I am when you take race off of this. And to say that we're going to give a holistic review of everyone except your race is pretty demeaning to the person whose identity is tied to their race. Hold on one second.
Oh, sorry.
For many students, it may not be important what their race is. But for those students who it is important to them what their race is, it's very dismissive and disrespectful to their own identity and self-identification.
Andrew?
I would just note that that's actually not what the petitioners in this case are in fact requesting. What the petitioners, sort of the gravamen of their challenge is that the University of Texas hasn't complied with the requirements of strict scrutiny. They actually don't ask, in terms of the relief and in terms of the rule that they would like the court to propound to preclude all consideration of race. It's not really a question, I think, that's directly raised in the question presented by the petitioners, and certainly not by the theories that they've put forward. What they say, and if I get it wrong, please don't attribute it to them, is that every aspect of an affirmative action program, every aspect of racial preferences, needs to be validated by evidence. There has to be a compelling interest, and that compelling interest has to be supported by facts on the ground. Their argument is that in this instance, the facts on the ground don't support the consideration of race. But that's a very different argument. I think it's a more nuanced argument than you give them credit for.
I'll take the bait, though. So I disagree. I think race should not play a role at all, no matter how much people use it to self-identify in their private lives, in government decision-making. That's the only context in which I will make this argument, is that the government should never, under any circumstances, take race into account. And whether it's demeaning or not demeaning really just sort of depends on what the government thinks of your race. If it likes your race, then I guess it would be demeaning for them not to take it into account. If it doesn't like your race, well, then it's awfully demeaning when they do take it into account. It just depends. And the danger, what we've learned from discrimination and segregation and all of these things, is that the winds change and the winds blow. And a racial group that is today favored will be tomorrow disfavored. I represented Asian Americans in the brief I wrote. And, you know, a long time ago they were, quote, the yellow peril. And now they're the model minority. Sometimes they're thought of well and sometimes they're thought of badly. But in each instance, somehow it doesn't work to their benefit. So it seems. nobody would want me to take a holistic approach in deciding whether to hire you or you or you or any of you at a job by saying, you know, overall, you're a good candidate, but I like the white guy better. Because just holistically, white guy makes me feel better. No one would want me to do that. And I just do not. I cannot see the difference in flipping the races and saying the same sentence.
Well, that's actually quite disingenuous. That's not actually what's being done. No one's saying the white guy makes me feel better. But when you're hiring, you may say that the way that he approaches management helps round out the team that we have. He's a bit more inclusive than some of our other the folks have other management styles, and that's beneficial. And to say that the winds of change flow when one race is on top and one race is on bottom one day also seems to me completely divorced from history and from what has gone on in this country, because it's not ever flip-flopped in the way that you say it's flip-flopped.
I completely disagree. Hispanics are on the ascendant in many states. They will soon be political majorities. They will have great power to control things like this.
Numbers don't equal power or influence.
Well, actually, I disagree. I think they do. When you control the legislature and you control voting blocks, they precisely translate the power and influence if they vote as an ethnic or racial bloc. If they don't vote that way, then you're right. But for them not to vote that way, we have to get past race.
And I think that the idea of this policy of holistic review is actually over time to get past race, because one of the key things that the Supreme Court viewed compelling was the idea of breaking down stereotypes that students have. And like it or not, most students come to college, and college is one of their first experiences of students of different races. And it's one of those actually quite rare instances in our society where we can be exposed to that variety of different views. And when most students come to school not having experienced any sort of diversity, they tend to have ideas that they don't really even know that their lack of knowledge is inhibiting them. And that's the type of atmosphere in which stereotypes flourish. When you put together students in dorms and in classrooms, and they realize that there are a lot of similarities across race and a lot of differences, that's where you start to get to the point of true learning. And I think that what Provost Lerman mentioned about diverse teams, there's a lot of evidence in the amicus briefs, but more generally about diversity also making us smarter, that bringing together people with different viewpoints and race among a broad diversity, because what UT is emphasizing here is not just racial diversity, but broad diversity, helps us think outside the box and helps us bring all of our society and all our communities' ingenuity to bear on our tough problems that we have as a society.
The real question, though, I mean, because this case is about racial diversity, right? On some level, whether we like to think of that way or not, doesn't the 10% plan, though, produce racial diversity? And if it does, then what's wrong with just keeping the 10% plan? Why go the extra mile of doing the holistic review in which you're also taking into account, once again, race for purposes of admission?
So UT looked at their experience with the 10% plan and actually a whole lot of other race-neutral alternatives and concluded after extensive review that it didn't fully achieve the educational benefits of diversity. It didn't because if you look, for instance, at African Americans in that 7 or 8 year period where they had no holistic consideration of race, African Americans were only 4.5% of the entire student body. Over 80% of classes had only 0 or 1 African American in the classroom. And with those types of experiences, there was a perception by the university that they weren't fully achieving and exposing their kids to the benefits of diversity.
Yeah, but that sounds like numbers, Josh.
Well, those are numbers that they looked at. So those
is
are
there
factors.
a numerical goal with respect to diversity? Is that what we're talking about here?
That's
problematic from the Supreme Court perspective.
The Supreme Court said that some attention to numbers was okay, and so those were some of what it took into place. But then it was also a qualitative analysis of what they interviewed students and determined that students still felt like they were often isolated, and in the Supreme Court's words, they felt like students were being asked by teachers, asked by peers, even often well-meaning and well-intentioned ones, to bring the Black perspective to a particular class. And when students perceive themselves as being a spokesperson for their race, it's a harder environment in which to learn.
If I could also add just an additional challenge with the top 10% plan, other than in addition to the fact that it relies on segregation, and there's something very sad about having a program to advance diversity that relies on segregation. But because it is relying on segregation, a lot of the minority students who are admitted through the top 10% plan are very similar. They have gone to the same elementary school, the same middle school, now the same high school. They've grown up in the same community, and you're not able to achieve what Josh called diversity within diversity. There's also the problem that you mentioned that sometimes as high as 80% of the class for the University of Texas gets admitted through the top 10% plan. It leaves the university very little room to shape who their students are. At one point, the University of Texas believed that it was a national school. But when 80% of your students have to come from within Texas and through this top 10% program, it really does take a lot of control out of the university's hands of what their student body looks like, and prevents them from creating the type of mix and diversity that they think can make for a more enriching educational experience.
So I agree actually with much of what, I mean, I don't even disagree with the benefits of not just diversity in general, because we assume we can get normal diversity, non-racial diversity through non-racial means. But even racial diversity, I don't disagree that it adds something. That it adds experience, it adds different perspectives, it adds all kinds of things. What I do disagree with is that it's compelling, that it's a compelling interest. Because if it were really a compelling interest, as opposed to just a regular interest, a nice thing, an important thing, we'd have a lottery. We'd have a lottery. Every kid above a C+ will have a lottery and they'll get in, and if that pool of kids is diverse in the way that the student population is diverse, then we'll presumably a random lottery over several years will have a diverse result. Texas doesn't do that for much the same reason they complain about the 10% program, because it doesn't make them good enough. It doesn't make them strong enough as a university. They want to be the best. They want to be great. They want to have smart kids. Well, pick one. Do you want kids with strong academics, or do you want kids with representational diversity for the group? But the fact that they're willing to trade these things off willy-nilly tells me the value they place on racial diversity versus these other things.
And just to be clear, Justice O'Connor confronted precisely that argument in the Michigan case and said universities shouldn't be put to the choice between getting a class that's diverse on all levels and racial diversity, and in particular between academic selectivity and racial diversity, and so rejected out of hand the idea of a lottery. And I think just to come back and try to stress where there's so there are some people who are, and some organizations who are friends of the court, amici of the petitioner, who want to challenge the compelling nature of the interest in diversity. But I think that Andrew made an important point, that the petitioner here, Abigail Fisher, is not taking on board those arguments. That she's really assuming that those benefits of diversity are compelling. And the question then becomes, has UT's plan met the demonstrated need in diversity? And I think that we can have the arguments from first principles, but I think it's very important not to get away from what this case is about, which is about, did UT's plan achieve those benefits that petitioner is not challenging?
I also just can't leave out there the way that we seem to have academic excellence over here and diversity over here, that as if those two can't coexist. And they can, and they do. So I just want to make clear that I don't want that to sit out there, that we have to choose between academic excellence. It's the way that we identify and measure academic excellence that's the problem.
I was merely quoting the university that said the top 10% program, while getting lots of people of color, don't get people of color with strong enough academics. It's not that I think one has to choose. Texas apparently thinks this. If they abandon their top 10%, they could go for stronger academic candidates. And you're right, they might lose some numbers, but they would gain academic candidates, and I'm sure there'd be lots of people of color in those groups. I'm not suggesting for a moment that that's the case. What I am suggesting that the university is contradicting itself repeatedly by weighing one versus the other as if there were a trade-off, as opposed to saying we're going to take strong candidates with interesting backgrounds and varied interests, but their race is not going to be what we use as the thumb on the scale.
This may be a little bit off, but I think it's also troubling, and it shows a deeper problem with our society, that folks who graduate in the top 10% of their class are deemed not academically ready. to attend the university, their state's top university. And so while we're discussing affirmative action, we obviously need to move back and have a deeper conversation at some point about educational equality at the K through 12 level, and not forget how that impacts the affirmative action discussion.
I agree. We should fix public schools and elementary schools, absolutely, and that would probably solve a lot of this problem.
A long enough panel and we could solve everything.
Speaking of which, I want to transition the conversation and talk about the legal challenge itself, what Andrew was getting at earlier, which is that really this case turns on the second prong of the analysis, not whether diversity is a compelling government interest, but whether or not University of Texas has gone about meeting that particular goal with sufficient clarity and specificity. Narrow tailoring is what the Supreme Court calls it. So Andrew, I want to talk to you a little bit about that. What do you make of the 10% plan itself? Not the holistic plan that Texas is adding on to it, but just the 10% plan. Is that one sufficiently narrowly tailored?
Well, in terms of narrow tailoring, I mean, the 10% plan is actually not subject to challenge in this litigation.
That's right.
And so, I mean, if your question is, would the 10% plan standing on its own be sufficient to achieve whatever benefits of diversity the court recognized in Grutter? You have to take Grutter by its terms, and this isn't Grutter. The facts were uncontroverted that if you assume that a critical mass is an appropriate measure of diversity and that therefore a university can have a compelling interest in attaining a critical mass of minorities at the campus-wide level, and that's what Grutter stands for, at least with respect to compelling interests. What's different in this case is that in Grutter it was uncontroverted that the university would not have had anything like a critical mass of minority students but for the use of race preferences. In particular, it had by its own estimations, and again, these were uncontroverted in the litigation, they would have gone to 4% minority student enrollment. With fairly extensive racial preferences, they were able to get up to 14%, and they felt that that was something that added a very significant degree of diversity to the campus. The facts in Texas are very different, and the University of Texas, while putting on this kind of Grutter window dressing into what it is that they're doing, it really, I think, has not grappled, at least when they were creating their program, with what it is that Grutter actually requires. Because the baseline minority enrollment under the 10% plan was actually fairly significant, and indeed the university itself was patting itself on the back shortly before the reinstitution of racial preferences by saying that they had achieved the same degree of diversity, the same degree of racial diversity, at least at a bare numbers level, that had existed when they had been employing racial preferences prior to the Hopwood decision in 1996. There are other aspects of the program that suggest that what they're going about in this instance is not actually what was approved by the court in Grutter. You've got the disparate treatment between Asians and Hispanics, despite that they exist on campus in similar numbers. The University of Texas talks a lot in their briefing about intra-racial diversity, but it's not something they actually seem to apply with respect to Asians, and indeed, it's not really something they consider with respect to groups other than sort of these big four. You've got Asians, blacks, whites, and Hispanics. So there are lots of reasons to believe that there actually is a problem at the compelling interest level in this case. Not that the university doesn't have a compelling interest in diversity as diversity. Again, that's not something that's being challenged in this case. The question is, do they have a sufficiently compelling interest to use racial preferences? And as I said, this is a very different case from Grutter, and I think the University of Texas has been struggling with that.
Okay, but I guess my question was to get at what underlies the 10% plan, because we often characterize the 10% plan as a race-neutral approach to achieving diversity, but to the extent, if Josh is correct, that the 10% plan relies upon residential segregation in Texas, then the legislature in adopting the 10% plan is engaging in race-conscious decision-making.
Yeah, it's actually a very interesting situation. No matter how this case were to turn out, even if the court were to hand down the strongest possible language against deliberate and intentional use of race as a factor in admissions, they wouldn't actually spell the end of this issue. Because you're right, I mean, the 10% plan was adopted for, at least in part, expressly racial balancing reasons. And that's something that went into the University of Texas, the University of Texas as well as the state legislature's thinking in creating this. That's not unusual. In the state of California, after its constitution was amended to prohibit the express use of race in admissions, the chancellors of the University of California went through a several-year review to figure out, well, what other factors can we use? What other factors can we find that will get us to the sort of racial numbers that we hope to achieve at each of our different universities? They weren't able to get exactly where they were under the prior regime, but in that race-conscious manner, they were able to get part of the way back to where they wanted to be. So it's not an issue that's before the court in this case, but I think what you're doing is I think you're looking ahead to the next round of litigation, I would have to imagine.
Mm-hmm. Well, I'm also trying to get a sense of what narrow tailoring means, right? You know, the Supreme Court's going to be debating this question. As a professor of constitutional law, I often debate this question with my students. But I'm curious, what would satisfy your conception of narrow tailoring? I already take it that Erik is on board saying, you know, no race preferences whatsoever. Consideration of race is unconstitutional per se.
That's a compelling interest problem.
Right,
There's a separate narrow tailoring issue, obviously.
So Andrew, what would satisfy you? In terms of narrow tailoring. What could Texas do?
Well, I don't know what Texas can do, but I certainly know what they can't do. And what they can't do is provide disparate types of treatment across different racial groups without some type of justification for doing so. What they need is an evidence-based approach that at least has some conception, maybe not a number, but at least some idea of what it is they're attempting to achieve, how it is that will help them to meet their goals, and then in a straightforward and conscious fashion, how it is that they're actually achieving that through their admissions process. In this instance, as I said, you have disparate treatment for Asians, you have disparate versus Hispanics. And that's something that suggests to the court, and indeed that was the very type of disparate treatment that troubled the court so in the Adirond case. You've got this disparate treatment that suggests that there isn't actually narrow tailoring. There's not a close fit between what the goal is and what the ends are. And it's something where in this case, Texas has kind of tried to avoid the use of numbers altogether. And in so doing, you know, they got themselves out of one problem, that's the Gratz problem. But they're still there in the Grutter problem. And you know, the common criticism of Grutter is that it basically tossed out the narrow tailoring analysis. And I think that's what the University of Texas thought they could get away with in this instance. But it seems the court may be a little bit more deliberate-minded in that inquiry.
So, you know, it would seem then that there's an objection to Grutter as well, lurking beneath your comments here, right? That you said they tossed out the narrow tailoring requirement.
Well, Grutter is anything but a paragon of clarity. The narrow tailoring, you know, the court, while quite pointed that it was following, you know, that it was undertaking the standard narrow tailoring analysis, same as in any other case, did apply a certain measure of deference. And this was effectively blown up by the Fifth Circuit in considering the Fisher case below, that deferred to the University of Texas both with respect to their compelling interest and with respect to their means of achieving that compelling interest. So really at no point have you had a sort of close judicial look to see if the university is going about what it actually said it was going about. And as I said, there are reasons to believe that it isn't. The disparity is one thing, and also the fact that if you actually look at the numbers here, as best anyone can tell, and the university doesn't really seem to challenge this, the number of students who are admitted under this policy who would not otherwise have been admitted, it's effectively de minimis. They allege that there's this enormous problem that they're not meeting what they see as being, they sort of covertly say, you know, an ideal which would be sort of the racial breakdown of the state of Texas. That's at least a benchmark that that the university consistently refers to. But at the same time, how to get from where they are to that benchmark or any other benchmark that they've identified, whatever it may be, they say there's a huge problem, and yet they take the most tiny, minute step in terms of actually achieving that end. And while doing that, classify every single student applying to University of Texas by race. It's right there on the front cover of their admissions packet. So if you sort of take this kind of cost-benefit balancing that the court most recently applied in parents involved, the court has said that's very problematic. There's a real cost to doing that type of classification. And when the benefits are tiny, minute, and in this case, they're actually quite consistent with what the benefits were in parents involved, the court's view is, well, that's not good enough. It's not worth the cost.
So Andrew's bringing up what I sometimes call the Goldilocks problem, which is because I believe that, or I'm suspecting that if there was greater consideration of race here, that would also be problematic. So you can't do too much consideration of race, and you can't do too little consideration of race. So if the court's really doing that, then if that's really where the doctrine's going, then it is effectively going away from the notion that you can consider race as part of a holistic policy. I don't think that that's where the court's going. I mean, I think that the policy here, in terms of its modest but meaningful impact, is a virtue of the program, not a vice. The program, in terms of holistic review, a full, and this goes back to numbers because some attention to numbers, but a full 28% of the African American students from 2004 through 2008 come in through the holistic review. Now, would all of those students be admitted through a system that didn't expressly consider race? Maybe not. But in a program where really the percentages and the numbers and the types of students coming in through the individualized review who were of Latino and African American was stagnating before this allowed some modest appreciation within the confines of the program. I just want to also take off from the disparate treatment of Asians and Latinos, because I don't think that that's a fair characterization of the policy. Remember, the policy only considered African Americans and Latinos as underrepresented, but that didn't mean that UT, in implementing the policy that it did, couldn't consider any student's race as part of their holistic program. Now, I agree that you have to consider, in the aggregate, African Americans, Latinos more to have an effective policy, but an Asian American from a particular community or context, Vietnamese students in Texas have a history of being less included. That's something that the university could take into account, and I think it's important to take into account. And those factors are important.
Two things. I agree with the Goldilocks problem. I'd call it the Grutter problem or the Kennedy problem, actually, because he sets up an incoherent and impossible to reconcile test, and then the university has to say, no, we're not doing numbers, but yes, we're getting numbers, but we're not doing numbers, but we're getting numbers. It's a little bit disingenuous. Either race matters and it's okay, or it matters and it's not okay, but we should pick one and say, if it matters, give me the numbers. If I need more racially diverse student bodies, give me the numbers. I don't see that as a problem intrinsically, other than I don't think you should use race. But as an approach, it's the more sensible approach. On the Asian thing, I find this impossible to believe. If the goal stated by the University of Texas is to increase the representation of underrepresented minorities, and Asians are there at 4 times their number in the population, that can only mean one thing. They have to go down, and underrepresented minorities have to go up. It's the only way you actually achieve the stated goal of the university. Now, maybe they lied about their goal. Maybe they lied about whether they're counting underrepresented folks and are really counting everyone. But they've given no examples of saying, you're Asian, you're in, or you get a plus. Not one. They keep saying, we could do that. But they never actually say they did do it. And the numbers don't bear them out. Yes, Asians are wildly overrepresented at Texas, but if you brought them up on their numbers, they'd be there at double the numbers, because their numbers are off the charts as a group. I agree with you. We shouldn't treat Asians as a group. We should treat Vietnamese differently than we should treat Chinese and Japanese who've been here for generations. I agree with all of that they're not the same, but the university treats them like they are. And the notion that they're actually giving a helping hand to the Asians, to the Vietnamese, but not to the Chinese, it beggars the imagination if this is actually the program that they claim to be implementing.
And the lack of transparency means that you'll never know the answer.
That's right. They get to make it up as they go along, because they refuse to tell you what numbers got there, what points they gave, who got helped, who got hurt. They don't even keep the records, apparently. So sure, I helped the white kid. I helped anybody. You can make it all up. Why not?
So, one of the issues that is not put on the table by the petitioners is a request to overrule Grutter itself, right? The petitioner's not arguing that, but certainly a number of the amici are arguing that.
Yes.
So I just sort of wanted to get the panel's thoughts on the likelihood that the court would reach out and decide the question not presented by the petitioners here, which is whether Grutter ought to be overruled. Deborah, why don't you?
Well, I'm not going to say what the court will do, but I
Prediction.
can say that there's nothing that has happened in the past 10 years for them to want to overturn Grutter and not respect stare decisis. What has happened in the past 10 years is that we have more support for diversity. That diversity is important educationally and in our corporations. We have an increasingly diverse society. The census is telling us that we're becoming a higher percentage of people of color. And we have evidence in California that perceived race-neutral ways of increasing diversity are not effective. So if we're looking at what's changed in the past 10 years, what's changed in the past 10 years supports upholding Grutter and not overturning Grutter.
The court also has an important principle called stare decisis. For the lawyers in the room, that's a term that comes trippingly off the tongue. For others, maybe not. But it is that the court respects its precedents. And since, for 35 years at least, the court has said that, well, Justice Powell had a decisive opinion 35 years ago in Bakke, and then the court in Grutter, the Michigan case in 2003, and even more recently in a case in 2007 called Parents Involved, the court said that diversity, at least in the context of university admissions, is really important. Justice Kennedy, it should emphasize, because a lot of people often look to Justice Kennedy as a swing vote of sorts. Justice Kennedy in Grutter, although he dissented on the narrow tailoring realm, it's important to remember that Justice Kennedy said that individualized consideration of students, as long as individualized consideration is safeguarded through the process to achieve diversity and expand opportunities for minority students, is a compelling interest. So I think that that part and really what the universities have stressed in this case, the 100 universities that came in, is how much they've relied on this long-standing precedent in their policies. So I think that all should be taken into consideration.
Yeah, but doctrines have life cycles, right? Just because a case was decided doesn't mean that the court never ever revisits it again, right? Think Dred Scott, right? Or Plessy versus Ferguson, right? So the courts can, in subsequent generations, completely 180 and turn that thing around. In this particular instance, we have changes in personnel on the court. That may be critical. We have Justice Kagan, who's stepping down, recusing herself because she's not going to, she can't participate in this because of signing on to a brief at the Fifth Circuit. So it's one of these questions that I think is important. Also knowing that that with Chief Justice Roberts, the court is a little bit more activist in reaching out and deciding questions that aren't necessarily presented. But the two of you seem particularly confident that the court is not going to reach out and decide. Grutter.
Hopeful.
Erik, what do you think?
Well, I think if let's just start with the assumption that they are troubled by the UT system and want to do something to make it less likely to happen again. I think it's more likely that they would try to narrow Grutter rather than overrule it, because that's a less painful and less disruptive way of doing it. You clarify some of the fuzzy language or the contradictory language, maybe give more emphasis to the restrictive aspects of it than you do to the permissive aspects of it. I'm sure there'll be a vote or two to overrule Grutter. I don't see 5 there just as a predictive matter, but perhaps to narrow it some ways. One of the things that might lead them there is, yes, the society is getting more diverse. California has shown some interesting results when they've gotten rid of preferences. One of the interesting things California's actually shown is that Berkeley is like 50% Asian now. UCLA is in the high 40s last time I looked. They may decide that, wow, affirmative action suppressed the heck out of Asian attendance, and that may trouble them rather than make them feel better. I just don't know which way that will cut. But I agree that stare decisis puts a decent thumb on the scale that will constrain how they go about, if they choose to reject this program, it will constrain how they choose to do it.
I agree that Grutter is more likely to be underruled than overruled.
Yeah. I think I agree in terms of that outcome. I mean, I don't think you're going to see an opinion by the court that says that schools can't take into account race in any circumstance whatsoever. What does it mean to overrule Grutter? I mean, is it this idea that diversity may be a compelling interest and therefore you can use race preferences? Right. I mean, that's not going to be overruled. But there are so many details of Grutter that are up for grabs. I think the critical mass concept is something that may well see the end of its life. I think some of the language with respect to narrow tailoring and how that was carried out. I think some of the language with respect to schools' burden to demonstrate a compelling interest may be overruled. But I guess a question that I would ask is, if one is in favor of race preferences, I mean, there are so many reasons that schools might wish to employ race preferences. They might believe that there are inequities among the races. They might believe that there are lingering effects of prior segregation and discrimination. They might believe that there are continuing effects of de jure segregation and disadvantage in the United States today. Grutter, it seems to me, for someone who might be in favor of remediating those types of problems, is actually an incredibly poor fit. It makes schools that wish to advance these types of different rationales, it makes them twist themselves into knots and undertake contortions to do what it is that they really want to do, which is not merely to advance diversity, but is to engage in something quite different. So it's kind of bothersome to me that in some sense the case is a little bit of a farce, because if Texas's primary interest were advancing diversity, this isn't probably the type of program that it would come up with. The reason it came up with this program and the reason it defends it on the terms that it's defending it is because that's what the Supreme Court has allowed and because it's ruled out other types of rationales. And so it troubles me, I guess, to some extent that the people defending Grutter, I don't necessarily just mean on this panel, but many people defending Grutter take it for the broader proposition that you can consider race in admissions, but without kind of thinking about the box that it puts schools in and whether it actually achieves what it is that they, in their hearts, are trying to achieve.
I mean, I do think that the way that Grutter articulated the benefits of diversity were tied into and recognized the role and the place of universities in the broader society. Grutter stressed the importance of pathways to leadership being visibly open to all segments of society. It talked about the military's experience when it wasn't diverse and how that undermined military cohesiveness. And it talked about the legitimacy of our academic institutions and how we must ensure, in order for them to survive, that those institutions are and remain tied to the communities in which they serve. And finally, it cited back to Sweat versus Painter, which is an important case here. It's a 1950s case about a guy named Heman Marion Sweat, who was denied admission to the University of Texas at Austin's law school solely because of his race. And in Sweat, which is really where the origins of diversity come from, the court critically recognized that you can't have an effective university if you're training students in isolation from the context of the community around them. That's what we're building on, and the importance of UT in this history is something that we shouldn't forget.
So, Andrew, you said something interesting, right? You were talking about the history. You said you were troubled to a certain extent because some of those other justifications have not been articulated. Turns out that some of that history is raised in some of the amicus briefs that have been filed, where they talk specifically about Sweat versus Painter, but they also talk about incidents on campus and recent incidents on campus. Is that relevant to this case, meaning for this Supreme Court in deciding this case? Should the Supreme Court even be thinking about the history?
Well, two quick responses. I mean, one, the way in which, when I have seen that those certain incidents have been discussed in different briefs, I mean, more recent history has been discussed, I think, in sort of subservient rather, to the diversity argument. And so I don't think I actually have seen many. There may be one or two. There are lots of amicus briefs.
Right, 72?
No, 90,
oh, no.
92, I believe.
Oh,
72 on the side of the University of Texas.
And then there are the other ones, too.
right. Sorry.
But they've been discussed in service of the mission of diversity as opposed to considering any of these other possible rationales that a school may have to engage in racial preferences. I mean, look, these things may not be relevant, but I think the question, is a broader question than that. There are lots of reasons schools might want to do these, engage in this type of program. We have reason to believe, and indeed I think Justice Kennedy in his Grutter dissent actually quotes some language describing an attitude among a lot of academics that there are lots of different reasons, not merely diversity. And diversity may not even be the foremost one, to engage in some measure of racial preference at the admissions level. And yet our debate, the things we're talking about up here, it's diversity, 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 and that's it. I mean, I think it's very interesting. I mean, the Supreme Court has put folks defending these programs into a very difficult and probably untenable situation. You can call it in a narrow sense this Goldilocks problem or the Grutter problem, but the real problem is a fundamental mismatch between what some people think in their hearts of hearts is the proper thing to do and the language by which the Supreme Court has given them permission to justify it.
That's right. It is a doctrinal problem at its core.
Yes, I mean, This is all sort of encouraging disingenuousness by the weird and contorted ways that the doctrine has evolved through Grutter, so that you can't say what you mean, you can't do what you actually want to do that would actually have a perfect tailoring to your goal. If your goal is to get more minorities, well then, add more minorities. It's very simple. But you can't do that. You got to pretend it's holistic. You got to pretend you're not doing it while you are doing it. You got to pretend that it's really a tiny little tail on the flea on the dog. Whereas we should really just talk about it and decide what we want. And these briefs that mention those things, for all you law students, you should understand that while technically they are not relevant to the narrow legal issues presented, nobody is foolish enough to think that it doesn't matter, that context, as we've said a dozen times here, doesn't matter. So of course it matters to which way somebody may lean at the end of the day on a fuzzy question of doctrine if in the back of their mind they understand that, well, there's still lots of legacy racial effects from past discriminations, or that it's going to hurt some other group, but depending on which side of the fight you're on, right? So those things just provide context. It may not be legally relevant context, but it doesn't mean it's unimportant context.
Deborah, I wanted to bring in your brief, your materials that you filed before the court, and in particular, in the context of a discussion about diversity, there is the counter argument out there that one of the downsides of diversity-based admissions policies is that it results in a mismatch of actual candidates with schools. So I wonder if you could just tell us a little bit about that.
Right. So there was an amicus brief filed by Professor Richard Sander and Stuart Taylor, and it argues that affirmative action actually hurts Black and Latino students because it gets them accepted to schools that they're not academically prepared to succeed at, and therefore they end up in the bottom of their class. They would be better off if they weren't accepted to those schools because we'd have this cascading trickle-down effect where all of those students would attend lower-ranked schools that they're better prepared for. I think that, first, I find it incredibly paternalistic and insulting that we would be arguing that Black and Latino students are unable to make decisions for themselves, that they can't get the information, they don't have access to U.S. News and World Report, they don't know the average GPA or LSAT at the law schools that they're applying to, and therefore we have to protect them from their own decisions, take away these opportunities to challenge themselves and attend academically rigorous institutions. I also think it's counter to what we as a society should be advocating. We should be advocating for students to stretch themselves, to push, to reach higher, to challenge themselves academically. A study in Crossing the Finish Line says that, in fact, the bigger problem is not mismatch, but undermatch, that students who are getting high LSAT scores, SAT scores, high GPAs, are not attending the schools that they qualify for. And one of the factors is the lack of diversity. They don't feel welcome in that environment. They don't feel comfortable. It's important to note that there are some briefs with people who are better at numbers than I am that have shown that Professor Sanders is relying on bad science, that that's just not good science, his mismatch theory. But also there are studies that show that completely disprove mismatch, that in fact, when you have students who, there was a study of African-American men, they looked at their SAT scores And the students who had low SAT scores but went to higher ranking schools did better than the students who had the same SAT scores and went to lower ranking schools. So to say that they would have been better off at the lower ranking schools has been disproved, that students do better the more challenging the school that they attend. I also think that that speaks to the benefit of the holistic review. Someone looked at those students' SAT scores and GPAs and saw something in them, saw that there were some signs of determination, leadership, drive, and they picked the right students to bring up to the more elite schools, and they were successful there. So I think it's kind of outrageous. I think Black and Latino students should be offended at the thought that they can't make these decisions on their own, and more importantly, it's been disproven.
You know, interestingly, I don't know the numbers. Lots of this actually makes sense to me. Outside the context of race, I think there's no question that some kid who pulls a B average, working a job with a single parent, having to help raise their siblings, is going to be capable, once they get to college, of doing better than a B. And so that, a holistic review, you should take that into account. I'm not sure what role race plays in that review, mind you, but I agree that numbers don't always tell everything, and that context does matter, particularly context that might explain the numbers and give evidence of future success. The other thing I do know, though, is that my poor brother-in-law, who was sort of a mediocre student, though went to law school and did fine, would have gotten crushed at Harvard. He would have gotten crushed. He would have been in the bottom of that class and crushed, unless something miraculous happened. But on the numbers, on the average, it wouldn't have worked.
You should have more faith in your brother.
I probably should. And I apologize to him for not. I probably should. But apparently the University of Texas feels exactly the same way, because they're complaining about the top 10 kids who aren't as academically strong as the kids that they want to let in the second 10% or the subsequent 90%. So it's not just me that thinks this, it's university educators. Whether the numbers bear them out or not, I have no idea. It's not my area, I haven't researched it. I'll take your word that in some level there's a pull-up effect. And it is condescending, I agree with you, it's condescending. But it's no more condescending than letting kids into schools they wouldn't have gotten in otherwise simply because of their race. I think that is exactly as condescending to them as it is to say you're not capable of making your own decision. It's you're not capable of achieving something on the non-racial objective criteria that your race has to count, where for generations, not generations, for at least, since Martin Luther King, we've at least hoped to get rid of race as a factor, positive or negative, I would think.
Yeah, which raises an interesting question, of course, as to whether it's even possible to make a decision without taking race into account one way or the other. It seems that history tells us that we take race into account whether it's mandated or not.
We do, though I assume in most of the law school classes here, if it's anything like my law school, you write your essay, there's a number on the book, and your name is somewhere else. And hopefully the prof reading that has no clue who wrote it until after the fact. There are ways of eliminating race as best you can. Obviously, if the essay is what it was like growing up a white kid in the South Bronx, well then, yeah, they're going to know my race.
Right.
But if you try to stop that kind of stuff and say, please don't write about your race, and you reject those applications that
or
have
your
that,
culture.
Well, perhaps.
Or your background, experience.
Some of it can be done without specifying which. So I'll tell you a great story about a kid who was the only kid of his race in his school, who grew up in a neighborhood where completely at odds with everyone else, who got beat up because of his race, who got mugged because of his race. Happened to be a white kid. But, what's the difference? I could write that story and you wouldn't know whether it was a white or a black kid until you knew the kid.
True.
I just want to touch on you saying that if you write your number on your exam, race was never a factor in your grade as your grade. There are actually quite a few studies that show that in many ways race permeates law school classrooms, on who gets called on who professors select to be their research assistants, on the way that letters of recommendation were written. So I think, again, it's not genuine to say that race doesn't play a factor in the educational environment, so that when I get to the point where I'm writing my name, writing my number, my exam number on that exam book, I'm not at the same place where other students are when they wrote their number on that exam book.
I agree that it's impossible to eliminate it entirely, but I think there are steps that can be made to minimize it as much as possible, particularly in the context of sort of nameless, faceless university admissions processes that may not know who you are or they're not calling on you. You're right, it had a bearing on how you were taught in grade school and how you were taught after that. And I think the best way to get past that is to stop counting it in the first place.
Let's talk about the essays, the actual questions that UT had. One question was, describe, in 2008 when Abigail Fisher applied, describe someone who has made an impact on your life and explain how and why that person is important to you. Or choose an issue of importance to you, whether personal, school-related, political, local, or international, and explain the significance of the issue to yourself, your family, your community, or your generation. Now, some students might answer those questions without talking about race at all, but an instruction to students to not talk about race in those questions may well end up self-censoring, forcing those applicants to self-censor. Or I guess the other thing you could do is you could, as an admissions officer, scrub out any reference to race, but that would be censoring by the university itself. If in our society, Anthony Kennedy said, the enduring hope is that race doesn't matter, but the practical reality is it often does. And if a student writes an essay talking about an issue that's important to them that has and relates to their racial background, I think that that should not be discouraged or somehow scrubbed or somehow said that it's impermissible. That's part of the application process, that's part of what goes into shaping them, and it's part of what goes into shaping how they will contribute to their university and ultimately their world.
Well, but then it will go in both directions. It will not simply go in for the good. It will go in for the bad, because the admissions officer who is racist and doesn't like a particular race will read that and score it worse than they would otherwise. And if the race happens to be Asian, because they think we got too many Asians, they will score them down for talking about their goal to be a doctor and why it's important to them given their culture and education. If the person is a traditional, good old-fashioned racist and they write about why the civil rights movement was important to them, they'll mark them down too. They won't say it. So you're right, you can't get rid of racism when human factors intervene. All you can do is try to put some boundaries and checks about it. I mean, and at the end of the day, even that is not determinative. I was at a bat mitzvah the other day, and they traditionally have the kids talk about what's important to them, and this girl talked about Martin Luther King, why Martin Luther King was extremely important to her in the civil rights movement. And while it could have been an African-American gal being bat mitzvah, it wasn't. And if she had written that essay, maybe it would be misleading to the people reading it, maybe it wouldn't, but at the end of the day, the civil rights movement can be important to lots of people, not just people who are African-American or Hispanic.
Okay,
But
we have a couple
it's important to
minutes
those people
left.
for different reasons.
What was that again?
It's important to those people for different reasons, and the reason why it's important to me is significant.
Okay, so we have a few minutes left. I want to open up the floor for some questions for the panelists. And if you could walk to a microphone, it might even be a little bit easier. Yeah, go ahead, go ahead.
I'm curious here, and listening to much of this conversation, that there seems to be an invisible standard that is not being spoken about openly, but is being evoked, which is that there are two identical people. So these fictional two identical people, and one of them is white and one is black or Latino, and then the black or Latino folks are going to get an advantage over their putatively identical white peer. And I'm wondering in what country and historical context these two putatively identical people, except for race, exist, because that doesn't seem to reflect anything I've, experienced in my 30 years in the United States, from the South Bronx, by the way.
Me too.
Right? That doesn't seem to reflect anything I know. So I'm wondering if you can defend this assumption of equality.
Absolutely, it's not an assumption. And the jurisdiction it exists in is the Republic of Texas, and they have a box. They have a box with a combined score, and that box is 10 points on AI and 7 points on this, and you equal 17. And so there's 5 kids in that box, or 10 kids, or 20 kids in that box that equal 17, and they, for purposes of admission, are identical. You're right. How they got to 17 may have been through different directions. But for all that the university cares about, they just draw a line. If you're over 17, you're in. If you're under 17, you're out. And so the only question then is whether race moved you from 16 to 17. That's the only question. So you're right. It's not realistic in our day-to-day interactions, but that's a criticism of what Texas does by reducing everyone to a grid box.
I don't think that's, again, what Texas does. I mean, it's not considering... It's considering students and their race in the context. There's no assumption that there will be 2 students from the South Bronx who are of the same race and have all practical experiences except for that. It's determining that there will be a lot of students with race and a lot of other different factors coming in, and the sum total may get them to a particular place, but not in any way because those people are identical. And in fact, the individuality is celebrated through a holistic review, quite the contrary.
Well, but their net point score is identical, and that's the only thing at the end of the day that gets them in or keeps them out. So you're right, they may have gotten to those points through diverse pathways. One played the flute, one played the tuba, one was from the north, one was from the south. All these things added up to equal a PAI score in their grades. And then the only question is, did race add something or did it not? And if the answer is it did, those are your two identical students who then are made different because of race.
But they're not identical as an underlying
They're identical
factor.
for the university's purposes.
They're identical with respect to the values that the university has identified as being important when they comprise their incoming freshman class.
Okay, other questions?
Hi, it seems like, I'm gonna sit down. It seems like the factor that we're ruling out is obviously race, but then isn't it just kind of raising the importance of other factors like being on debate team or playing the tuba? And it seems like playing the tuba is a little less significant personally to me than my race. So it just seems like what we're saying on one end is that other factors, except for race, because maybe that's taboo, are important, but isn't it giving a little undue importance to kind of the arbitrary factors that could be involved, like athletics, like, you know, I don't know, other after-school activities. So if you guys could just speak to that.
Sure, I agree with you that there are lots of factors that universities take into account that strike me as not terribly important, though I think debate should be the top factor on all of these applications, particularly for law school, just all you can hear. But the other factors, you're right, there are some trivial factors. I mean, the one that comes most commonly under criticism is legacy, right, legacy admissions. And I'm not a huge fan of that, though I understand why schools do it, because they come with money.
Not Nikita.
But so you're right, but that doesn't answer the question of whether we should let race in. It just says that the other holistic factors have some work that needs to be done on them too, and we should perhaps reconceptualize what we want out of our student body. You're right, race is important to individuals, but it is taboo. It's taboo for a very good reason, is that historically, as far back as mankind remembers, it's been used to include and exclude people, and nobody wants that to be a factor in government decision-making. Well, not nobody, but I don't want it to be a factor in government decision-making.
Okay, we have another question.
Hello. My name is Alicia. I just graduated from Spelman College. And so if affirmative action is not a viable option to assess individuals for jobs or education, how do corporations or schools take into consideration hardships or struggles that correlates with their race? So if an individual has a C+ average because he had to babysit, or you know, I read an article on the Wall Street Journal about if I was a poor black kid, I would go to the library and study really hard, but if I'm gonna get shot on the way to the library, how do we take into consideration those sorts of aspects where they could have achieved the same as their white counterpart or whichever counterpart which could study or get high SAT scores, but they weren't able to do that because of their environment, which is connected to their race?
Go ahead. I'm sure others may have a better answer to that question than I do. But I think it's very interesting in the way that you asked your question that you were describing particular factors in somebody's background that actually in and of themselves weren't race. In other words, somebody walking down the streets in a very dangerous neighborhood, someone who had a disadvantaged upbringing, someone who lived under a threat of violence. These things may or may not be correlated with different types of racial backgrounds in different parts of the United States. Beats me. I'm not a statistician. But I think it's very interesting that when it comes down to it, what we describe when we talk about specific instances of hardship, it isn't race in and of itself. It may be things that are correlated with race or that are imbued with racial considerations. But I think it's sort of telling that when you think of disadvantage, it isn't the race qua race that's actually disadvantaging.
I just want to disagree with that. There is racism. in the world, and whether you come from a privileged background or from a poor background, race is relevant and often to the detriment of minorities. And so when people say we should just use socioeconomic background instead of race and get the diversity that way, it's a problem, because people believe that because there's a disproportionate number of blacks and Latinos that are poor, it means that the majority of the poor are black and Latino, and that's not true. The majority of poor people are white, and so if you use factors like socioeconomic status, you'll create opportunities for poor white students, which we should. I think we should be creating more opportunities for white students from low-income backgrounds, all students from low-income backgrounds, to get a higher education. But we shouldn't fool ourselves to think that we're going to achieve racial diversity, racial equality, if we use socioeconomic status. In the end, we'll have more poor white students. That's wonderful, but we shouldn't think that we're going to achieve anything racially. And I do think, I may be in the minority, that we should want to achieve racial diversity. Race is significant in the society. Race is significant to individuals. Race is significant as a society, whether or not we want to accept that. And so we should stop shying away from acknowledging the importance of race, the continued importance of race, and the need to address it head on.
And I want to add one point to that. Race is one of these things, it's a constituent element of people's personal identity. It's sort of a, when I talk to people, I often have to make reference to my race, not because I think it's important to do so, but because I've had some defining experiences that are racial in character. I often think of the fact that I was bused to high school as part of a desegregation remedy. It's one of those things that define my high school experience. It's race, right? It's hard to talk about that particular experience without reference to race. And I think I would have been at a disadvantage when I was applying to undergraduate if someone had asked me to talk about one of the most significant experiences up to that time in my life and not be able to mention race, or for a decision maker to signal that race was not an important point of consideration when trying to evaluate who I was as a person. So I think the question is exactly right. I mean, it's hard to imagine, at least in some instances, being able to talk intelligently about your experience without reference to race.
I share when I applied to law school, wrote about some of the experiences that pushed me in the direction of focusing on race discrimination. I was bused in elementary school in Connecticut as part of a desegregation plan, and then when I was in undergraduate, this was a large part of my essay. My first semester, I had a note slid under my door that said, "Go home and before we send you home in a pine box." How can I convey that and the impact that those two experiences have had on me without involving my race? How can they judge me in those experiences without being aware of my race and acknowledging the significance of my race in those experiences?
But I thought the question was whether they should judge you on the basis of your race or based on the experiences that you've had tied in with you. I mean, I think that there is some amount of distinction in that.
Well, I actually agree with you, though it only pushes me back to my lotteries idea, Justice O'Connor notwithstanding. If you want fuzzy, holistic, let's look at every individual as an individual, then you're going to get race into the decision process. That's right. The trouble is, if people are incredibly unreliable in which way they use race in the decision process, especially racist people. It's amazing how they sneak that in there.
Well, you're saying, you're assuming that if we take race out as a positive consideration, that the racist people disappear. The racist
no, I
people
do a
will still
lottery.
be
I wasn't joking about the lottery. I don't think Justice O'Connor has really the better of that argument. I would say if you have the academics to potentially succeed, we're doing a lottery and you get in a state school. This is different in a private school, by the way. My opinion on private schools.
Numbers don't say everything, right? We show that
they don't say everything.
Show that numbers don't show who has the drive to be a leader, who has the drive and determination to succeed and overcome adversity. Numbers don't say everything.
They don't. That's right. But there's a lot of good schools out there, and a lottery is at least fair. And I don't want the government doing this. The other thing the government could do is just get out of running universities to begin with, and just pay for education, right? Just give everybody a voucher to go to whatever college they want, and then those private schools can discriminate all they want.
Subject to Title VI.
To repeal it.
Now, we have two more questions. I want to get both of them in. There's one here and there's one there.
Hi, my name's Stuart Taylor. I'm co-author of the brief that Deborah Archer attacked as paternalistic and insulting.
Welcome.
I want to respond very briefly. I could go on about the multiple mischaracterizations of our brief in her brief, but I won't. I will just mention one false premise of what she said here today, and then ask her just what's wrong with the relief requested in our brief. The false premise is that Black and Hispanic students who are admitted based on racial preferences have available to them all the information they might want to consider to make a fully informed consumer decision on whether it's good, whether this university or that university is good for them. In fact, the universities conceal this information as much as they possibly can, not only the size of their average racial preferences, but also how students admitted with various academic index scores or other measures of academic achievement, how well they do. Do the ones who want to be pre-med stick with pre-med? The evidence suggests no. Are graduation rates as high as white and Asian rates? The evidence suggests no. Are grades as good as they might be, and is intellectual self-confidence nurtured as it might be in a different university? The information is no. The universities have systematically misled applicants for decades about all of these things by suggesting that no matter how much lower your scores or grades are than your classmates, you're going to do just fine. Now, our remedy, contrary to what you suggested in your brief, our remedy doesn't say ban racial preferences. It says two things, and I'd like to know what you think is wrong with them. Number one, full transparency, full disclosure. Universities should make public all the kinds of information I'm describing, make them available to applicants for the sake of informed choices, make them available to the public for the sake of informed policymaking. Number two, racial preferences, preferences for people based on race who are, in individual cases, more affluent than more qualified members of other races, that those preferences should be discontinued. In other words, the child of a white cab driver or of an Asian seamstress should no longer be denied admission in favor of somebody who's the child of a doctor or lawyer who has lower qualifications otherwise. What's wrong with those?
So first, you mentioned there's a lot. So let me start with the remedy. I think trying to put out there that we're going to list everyone who got a racial preference is problematic for a number of reasons. Number one, we need to stop calling it a racial preference. No one's getting a preference. It's not a plus factor. It's not bumping you up, regardless of what they want to say about the boxes. So calling it a racial preference is misleading and disingenuous.
The Supreme Court called it a racial preference.
And I think they're wrong. So hold on, right? Okay. So you say that the black child of a doctor shouldn't have any consideration for the fact that they're a black child of a doctor. Again, it assumes that race is not relevant. Okay. Can you move on to the next questions? I'm not going to engage in a back and forth. He's not going to let me answer the question. So
go ahead, but I just say that you...
It's okay.
All right, one more question.
Yes. I'm just going to start off by saying I'm not a lawyer. I'm a professor of higher education, and I consider myself to be a social scientist. So I'll inoculate myself by saying that. But I did want to say, just to the comment before this previous one about not having the stats to back up, talking about a correlation of SES versus race and why not just, consider SES instead. I think what's being missed in part of this discussion is the fact that race is a signifier of a social condition in this country. We have very unique historical context that should not be ignored, and a lot of, preponderance of evidence that has been done in terms of social science and looked at things like wealth, intergenerational wealth, advantages that come with, so upward social mobility show that for African Americans in particular, the same kind of advantages do not come with having college-educated parents, do not come with having the same kind of income level. And so I think that part of the problem is we're looking at this issue from a very kind of individualized perspective and neglecting the broader structures of society that impact, and racialize individuals' experiences, whether we want to talk about it or not. And so I would like to hear what the panel has to say in response to that.
You know, I find it fascinating, the phrase race as a signifier of a social condition, because once upon a time, if one took race as a signifier of other presumed facts for any given individual, that would be called racism. So if race is indeed, well, I don't mean to call you racist. I didn't mean it that way.
No, I want to respond to that. I'm talking about if you look at the fact that you know, this black child of a doctor, in terms of advantages of schooling, the advantages experienced by that black child of a doctor are smaller than that of a white child of a doctor, of a white child of a white doctor.
Sure.
That's what I'm talking about. I'm
Okay.
talking about the fact that we can't, you know, regardless if we want to forget history.
Sure. I understand.
It can't
I understand
be
the point.
just, okay, now from this point forward, let's act like we're all equal.
So if the black child of a doctor still suffers some various and sundry disadvantages in terms of how they go about getting educated, how they're treated in class, how those sort of fall into the category of the earlier questioner who says, you know, there's all these socioeconomic, and I include the socio part of socioeconomic there, that really can hinder you. And it can hinder you if your parents are doctors, it can hinder you whether or not. I'd rather focus on those in any given cohort of kids of how have you been hindered, rather than use race as the proxy, assuming you've been hindered, even if there is a strong correlation. Because otherwise it opens the door to using race as a proxy for a lot of things that I think you'd be more disturbed for people to use it as a proxy for.
But the dangerous point here is that across a whole variety of aspects of our society, race still matters. It still matters in terms of disparate impact on the mortgage crisis and the economic crisis that we're going through.
How does it matter?
Because the studies show that controlling for a whole host of other factors, including economics, it turns out that homeowners who are African American and Latino tended to be more subject to predatory lending than other minorities, holding constant.
Holding constant education, holding constant socioeconomic status.
Yes.
I have to tell you that I find this miraculously unlikely.
And I can
we can forward you the study.
The one thing I've learned about social science studies is they are notoriously terrible about controlling for alternative factors.
I think that's right. Okay, folks, let's wrap it up. I want to thank our panelists for having a wonderful conversation here. Andrew Grossman, Erik Jaffe, Josh Civin, and Deborah Archer. I also want to thank Provost Lerman for taking the time to stay with us this afternoon and hear this conversation. I also want to thank Vice President for Diversity and Inclusion, Terry Harris-Reed, who is also in attendance and helping us as well, and Dean Morrison, who organized this entire event. Thank you and have a great afternoon. Oh, upstairs, hold on. Upstairs, there's a reception, and of course, mark your calendar for October 10th, which is the day that the case will actually be argued before the Supreme Court. So we'll see you upstairs.